but then you're assessed that whatever the fees didn't change because the campaign, it's all, it all overlaps, but I can't remember the top fee, whatever the highest amount is, if you don't file it, that the Secretary of State could assess that fee for not. So there is some overlap. The other thing is, and I don't remember, I don't have the bill in front of me, but if somebody moves property to conceal it so they don't have to disclose it, whether that one should be an ethical violation too. Right?
That's not in here.
Yeah, and I think it was in
If
our
you-
draft
yeah.
for the commission's rules. So the rule would work together with the statute. You file it, but there's some additional requirements, such as you can't falsify it or you can't move property around for the purpose of concealing it when you do this for the public officials under the commission's jurisdiction. So whatever we need to do for a rule, we can include, but just gauging whether the commission still wants to pursue that or not, now that the legislation passed.
Well, if we don't do it, it's still, there's still some enforcement of it, right? Doesn't have to be us.
Yes, so the late filing fees apply regardless of what the commission would do in rule, because it's in the statute.
Okay, what about criminal charges? Is that in here?
I don't think it's in the actual bill, but it might overlap with some
Yeah,
criminal
there's
statutes
some,
for falsifying things.
yeah,
I can't remember for
falsification,
sure.
yeah.
I didn't bring my 16.1.
Just in general, when you're filing something, if you falsify something. So there is some overlap with criminal stuff.
Yeah.
There's just no ethics violation that attaches short of a prosecution because it's not in the bill itself. So if the commission still wants to pursue that, we will need a rule to do it.
Hmm.
So I think we're looking for direction on whether the
If you wanted
commission,
to do
yeah,
it.
wants Logan to draft that or not.
You know, if there's, this is my opinion, if there is some other enforcement by the state's attorney or the Secretary of State, I'd just as soon let them do it. You know, we've got other things we're doing, so.
It won't be the state's attorney, it'll be the Secretary of State covers it.
Yeah,
We'll do both. If there's
Oh,
a
if there's a
criminal-
violation, okay, yes, then,
Yeah.
okay.
But there may be situations where gaps in authority or gaps in, that's where, if there's a gap, that's where the commission could step in.
yeah,
So let's say, for example, if somebody falsified something, we get it as a complaint. I think so-and-so falsified their statement of interest. Now we have a discretionary criminal referral. If there's a criminal statute for falsifying that record, we could send it to a state's attorney. And they could, or they may or may not prosecute it. Let's say they don't. We get it back and it's clear that they did actually falsify the record, we'd have to dismiss it because there's no civil
yeah.
correspondence.
There's also an intentional, the criminal violation has an intentional
That's what it is.
intentionality attached to it. That's where there's the distinction.
So that's kind of the gap that we wondered if the commission still wanted to pursue a rule or not.
It would be a fairly simple movement, right? Just to cover the gap. That's all we want to do is cover the gap, not expand beyond that.
Yeah, we wouldn't reinvent the wheel. The structure of how the statements are filed and everything is in the statute. So it's, you cross-reference the statute, falsify it.
Okay,
As far as workload, it wouldn't be a lot for me to draft it if that's a concern.
so we have a gap and it would be tough to fix. It seems like it's worth our while. Any other discussion? Comments?
No, I'm fine with Logan drafting something. I just, so I'll take back what I said before. give Logan some more work.
I'll draft it, Ron, and then you can
Okay,
decide once you see it. How about that?
that's fine.
Okay, so that's guidance we're gonna give Logan, and then go ahead and draft that or put it together for us, so cover that gap and everybody will be happy.
I certainly will.
Okay? So the next one is education and outreach discussion. The main thing here for everyone is, as a result of the legislature not providing us any support, is to have an open discussion about, you know, one of our things and what Logan and Rebecca and Alicia have done really well is the outreach, the education outreach. It's very popular, done very well. The problem is, without any support, is I think that has to fall to a much lower, I won't call it priority, but a much slower, much slower priority, and and our folks should dedicate less effort to that because it puts them behind on other aspects. So the purpose of having that on here is like we can have that open discussion, like we didn't get the support, so our staff is simply not going to dedicate a lot of effort to that.
Have you noticed the pressure of doing that?
The pressure of doing education.
Yeah,
So I'm going to take a little bit of a historical perspective, Ron. I think when I stepped in, or when you guys brought me on board as executive director, I think there was at that point a lot of criticism or a call for, let's call it, more education from the commission. I remember that being a big focal point, and that was one of the things that I was asked to tackle and come up with a plan for how we're going to address education. And now, my memory may not be perfect, but I believe that was the idea.
It was part of the interview for you too.
Yes.
mhm.
So what we ended up putting together was what's in front of you is that educational initiative, which is really just a kind of a step-by-step and aspirational initiative of what we hope to accomplish over, and this is not well defined in the timeline of what timeline it's going to be, but how we're going to do this. And so I do think that we reached out to individuals to provide education, right? In the sense of we've reached out to legislators, we reached out to lobbyists, we've reached out to the public, right, to have educational sessions. But there's also where we get requests. Specifically, that's coming from boards and commissions. Usually they request for us to be there and present. I think that our boards and commissions are probably the most neglected when it comes to education because there's so many of them. And what we would have liked to do is create more accessible documents so that they can, learn the quasi-judicial rules and the conflict rules, because they're like you guys, where they're only meeting maybe once a month or maybe once a quarter. And they have professions, and because they are part of the profession that they're regulating, they have inherent conflicts of interest.
Mhm.
So I feel a pressure that we need to make sure that we are educating that particular stakeholder group, as well as all the other stakeholder groups. There's also, so yes, I think now if I put that on myself or is it external, I'm not sure. But I also think that there is, if you look at ethics commissions across the country, there was a study done in 2022, okay, the beginning of 2022, and it showed that there were 36 jurisdictions who provided proactive education, and that they found that that was helpful to address problems instead of on the back end. So do I think that education is important and that I feel pressure to do it? Yes, because it's kind of one portion of what an ethics commission is supposed to be doing. It's the core responsibilities. But at the same time, I can say that I think our resources are stretched particularly thin. Logan and I in particular, you know, Alicia has to stick to a 40-hour work week for the most part. We have allowed overtime, so that's given her some flexibility. But Logan and I, many weeks, particularly in the early parts of session, we were working well over 40 hours a week. And to the probably I can say probably to the extent that it's not sustainable in the long term. So do we feel pressure? Yes. But I think also the legislature was very clear with, they didn't think we needed to do it, which was interesting given the context that we've had in previous sessions and previous discussions with the legislature.
So that being the case, it's like, yeah, the legislature just doesn't believe in that role. Even though it's in the Constitution that it's part of our responsibility. But I think it has to take a far back seat. Now, when you consider, like, also as part of the discussion was, you know, the complaints, the time to resolve. So our staff effort has to be on that. And education, it takes, even though it's a proactive method to accomplish things, it's going to have to take a back seat. And matter of fact, I want to say it's more than just a lower priority. It's just something that can't be done unless the stars align and the moon's in the right place, and like it's like, yeah, we can do it because we're doing nothing right now, you know, kind of thing. So, but that's kind of where I'm at. That's seeing what over the session, how the staff spend all their time on the session. I realize that's not the same. It's not the same routine as during the year, but still, there's a lot of backup and complaints, things that could be handled, and I just think the outreach has to take a back seat.
Dave, I agree with you, and I want to say one more thing on this. With education, we could possibly reduce the number of complaints so that we wouldn't have to spend as much time on complaints. If we had education that would, I don't like the word stakeholders, but that's what we're using. That if we can tell our stakeholders, give education to our stakeholders, maybe there wouldn't be as many complaints, and then our staff wouldn't be stretched that way. But right now, I agree with you. I don't think we have much choice but to have education take a back seat.
I agree with both of you guys. During the session, we got quite a bit of flack. We're taking too long. In general, they complained about that. And the only way you're going to solve that problem, and obviously that's our job, is to give it a backseat. I'd hate to say gone completely, because hopefully there are ways that you can prioritize and do a few things in education, you know, that don't take as much time maybe to put on, and rare focus groups that maybe address more, you can maybe work with more people for the same amount of time. But it's not right, and it's the wrong path, but that's To me, that's the path they put us on.
Yeah, it's the path we were given. Now, a couple of things we could take advantage of. The website, the FAQ section is excellent. So, I mean, we can not market, but we can highlight the fact that we have a website where there's a lot of information available, particularly in the FAQ section. That's a wonderful resource. I think that can help in the interim. So we can, I mean, it doesn't mean we give up on it, but we reference our website. We reference, here's something that can still be used, but our priority has to be on those complaints and the things that are necessary to accomplish what we do, or to accomplish what has to be done as a part of the routine efforts, operations of the commission. And education outreach will simply have to take a backseat. And I guess the whole purpose of this discussion is to give our staff permission to let that take a backseat and concentrate on the more pressing things.
So just for the commission's information, when we talk about priorities, how we currently prioritize or kind of division of labor, right, is 30, roughly, I'd say it's probably more like 20%, but 33% of my position is geared toward education. 33% of Logan's position is geared toward education. The other 66% of his is split between general counsel services, providing the commission, general counsel services, working on advisory opinions, working on potential rule adoptions, and then 33% is complaint. So basically, we're taking that 33% of Logan's workload and dividing it between general counsel services and complaints. And then I think, with my 33%, that can be reallocated towards developing our case management system and other things as well that we are going to have to do. I think it's really difficult to walk away from the education aspect of it because it is the best way to address ethical concerns and potential ethical issues. But I think that's probably how we would reallocate resources to do that. So Logan's time is, I just want to make it very clear for the commission, he's not going to be able to just complaint work still.
Yep.
He still is going to
Still
have
on
general
duty,
counsel
yes.
services and then rulemaking that are still going to come into play on this.
For education, would it be possible, going back here, you've identified A, B, C, and D. Would it be possible to prepare for lobbyists, a 1 hour presentation for lobbyists that would be accessible through the website and maybe on a YouTube platform or something like that? So if you're a lobbyist, here are the essentials that you need to know. And then say to the lobbyist association, if there's more than this, you're kind of responsible for that. And the same way with if you're on a commission or a licensing board, here are the minimum things that you need to know as a member of a licensing board. The one group of people and the legislators, the legislative council does provide guidance to them at the beginning of the session. But the one group that really is out there all by their own are candidates. And if you watch the legislation this time, there were a raft of bills on campaign finance, campaign reform, but they're not in the legislature yet, so they don't have that. And they may be getting misadvice from organizations. So would it be possible to focus on you can call it modules, but 1 hour CLE type of sessions, that if you're doing in this activity, here are the minimum things you need to know. P.S. We don't have time for more because we don't have the funds.
But you still have all the presentations you made, already, you still have those, right? Can we not use those
Pull up our education
as,
page.
as reference then, so that just the very thing you're saying, Murray, is that gap for candidates, because you covered that, there was a couple, then reference that and hang it on our website. This
So-
is for candidates, here's how we reference it, but
So if you go to our education page, you can see that we have, so the lobbyist learning session, which Murray, I think would probably be what you're looking at, right? We actually we recorded that so that we could make it available. So I would say that falls within that bucket that you just asked about. We also have the North Dakota Citizen one, the one that was just open to the public. We didn't record the legislator ones because those were in our office and they were small group. And then we have our 4 Dakota dilemmas, which are by topic. What I would actually, I think I would prefer, because we have already quite a few video
you
information.
got them already.
Yeah.
Just reference them.
Yep,
Or,
but I think if we would create a guide for each of those by group, that would be in written form. And then at the end of that, say anything beyond this is, we don't have time. I think we'd say it nicer than that, but I think if we take that idea that you had, but put it into a writing format, and then we could put it up here by group, right? I think that would nicely supplement the videos that we already have.
And I see that the timing of videos is all about an hour. 57 minutes, 1 hour, 5 minutes, 58 minutes, 1 hour, 20 minutes.
so the information is out there.
Yeah,
And we don't have to, or our folks don't have to spend more time in developing that. It's just simply now make the public aware that that's available for them as a resource. And I always go to the website, but I don't click and I don't get sent to the YouTube site, and that's a wonderful resource.
It is. Now, I don't want us to lose sight of, this is not, if you look at what other ethics commissions do for education, this is bare minimum, right? They have continuing educations.
Yep.
One of them just started doing which one was I looking at? Oh, now I'm going to blank on which one it was. It's either Hawaii or Oklahoma, because I was looking at those two most recently, that they actually started we're going to have a 1 hour every month, and anybody can come and learn about the ethics commission. And then it was, a repeated thing, but they opened it up and they did it in person and by teams, right? So there's a lot of different platforms. There's a lot of different teaching methods that go into teaching ethics. And so I want to be
They're
very
also
clear, this is a
staffed
bare
for that.
minimum, but they're also staffed,
For doing
yes.
better than the bare minimum. So we're not staffed for that.
What was that? Oh, the complaint was out of date, yeah.
These videos too, they'll require updating because now number 4 up there, the complaint one with this legislation with Senate Bill 2004, that's out of date.
Yep.
And it would need updating, so.
Well, for now, well, you guys have to look at your workload. For now, if something is out of date and providing incorrect information, we just have to take that down. I guess I'm advocating that you guys don't spend a lot of effort fixing everything now, that things have changed. It's like, take a break, or not take a break, what's the word? Mark those that are out of date as something, some marking that update required or something like that, so that folks know that these aren't totally accurate. So whether we make them unavailable, I'm not sure what the best is for that, or simply annotate that this information needs to be updated, and they can still look at for the reference of what's still useful. I don't know. But, I mean, we have a great resource out there. Everything you did last year, over the last year or more, in the way you hung it on the YouTube site and our website, the links, that's a wonderful resource. So we just have to make the public aware of that they can use that. And probably like when the people check with you, they can do this. Well, here, take a look at this. That's available for us now. And say that, well, we're not staffed to do that. Or no, we weren't resourced to do that. But here's what we have.
Just do the best you can.
Yeah.
I go back to the concept of YouTube. And I'm on YouTube a lot because if I don't know how to do something or I want to learn something, I'll go on to YouTube and some expert on there, some not so expert on there, but some expert on there in 15 minutes is going to go through and say, here's how you do this. And I'm thinking that if there's a similar kind of a program for different topics, if you want to be a candidate, here's some things you need to know. If you want to be a lobbyist, if you want to serve on a licensing board, these are some things that you need to know. Make it available to them. Because you don't have the time, we don't have the time for you to go out there at a request and present to one of 150 organizations. In fact, just can't do it. And you don't have the time to respond to candidates who need information. And so I think that kind of a concept, the YouTube platform concept, is the most cost-effective way to get the message out. That's my personal opinion.
Yep. So I think that's, if you look at our educational initiative, that's what we were envisioning in 3B, is longer 5 to 10 minute videos that provide comprehensive information but are limited in scope. And so creating those, even to do that though, so before we even get, yep, we can create a video and put it up on YouTube, we need to have a program that creates a video like that. There has to be, if I'm understanding this correctly, we don't have a video or a editing format for videos, correct?
Correct.
Because we use
Canva.
Canva and Teams when we did our Dakota Dilemma webinar series, but what we don't have is a software that we have not maintained or that we've gotten, right? And the state doesn't have one available for free. Now, correct me if I'm wrong.
Not a creative video maker, no.
Yep.
So I guess I wasn't thinking we'd switch their effort to something else. Their effort just needs to be, so I'm just envisioning that we'll take advantage of what we have out there already, just make the public aware. And for the changes, that, or those parts that are not going to help you because it's outdated, then that's a different discussion. But how do we handle that? What's is the effort to update worth? And is it a smaller amount of time and is it worth it? That's what you guys have to decide, is it worth it? But I guess what I'm saying and what the commission is saying is that's not a priority. So, is that correct? Anybody else?
No, I agree.
I agree that it's not a priority, but if you're going to get something out, it would be to get it to the widest audience at the least time and cost. And with going back to the YouTube, I like the idea of a biennial summit, but that's not workable with what we have.
Right.
But with YouTube, you get it out to the people and wherever they are geographically and whenever in the evening they want to do it. So you're getting it to them convenient. But I just see it as the most cost-effective, time-effective way to get the information out with no appropriated money. That just,
Thank you. So that's, for me, I want it on record that because of the circumstances of the resourcing of the North Dakota Ethics Commission, the education effort that we have paid attention to, that we have put into our plans, is now being diminished in its priority. We know we've got good stuff out there already, but could still go so much further. To me, this all ties into, again, why the Ethics Commission was formed, the whole thing about accountability, transparency, helping people understand. And yes, you've got the stakeholder groups, and I know candidates, new people, that, but we have existing bodies that need education about ethics. Because again, from my perspective, there's things I thought were in place for that process or that acknowledgement of these things that would be there, and they're not there. So then it's falling to us. You know, to me, it's like a catch-22 in many ways, because now they're complaining about our complaints and the number and how much it's risen and we're not getting to it. But let's stifle them with the number of days that you got to get to this in 180 days, otherwise it's done. But then they don't give us the resources. So it's like, so that has, to me, this has got to be, through this forum, publicly acknowledged. Okay, fine, here's where we're at. And it does not negate the caliber of our staff, the caliber of what's up there already. And we've all had part of that. We, the commission, we've directed, do this, put it up there. And it's very good. It's very good. And I'm so disappointed because I also saw where it could go, where it could be, had we gotten that FTE. And I don't want to belabor it, you know, whatever. So I know where we're at.
I have a personal experience from Tuesday today, from Sunday. I was invited to speak to a church group in Bismarck on Sunday about a topic. I talked through the topic and one person said to me, "Now you're on the Ethics Commission, aren't you?" And that spun off to about 40 minutes of questions about the Ethics Commission. People want to know about it, but there aren't ways for them to find out so much. So, I mean, I was surprised, I was shocked that they knew enough, and they've been following the bills in the legislature, and they say, "Why aren't you getting funded? Why aren't you getting funded?" I told them.
And did you get a question? Why aren't you handling this or that?
I didn't get that specific question.
You know,
Why isn't
you know
that-
what I'm talking about.
Yes, but why isn't the legislature funding you to do the job?
Well, and yeah, that's some of my friends, you know, I sit on this body. Gee, they haven't been treating you very good. How come? I'm like, yeah, that's a good question. Why don't you go find out? Let me help you find out.
They were more knowledgeable than I thought and asked some very probing questions. So, okay. And then they said, and furthermore, we want to talk about cemeteries. And I looked different direction.
Any other directives for us?
I think we've given you like the permission to hold back on what was a large part of your effort last year, which was very successful, but we give you permission to prioritize differently this time. 33% of your effort that both of you applied to it, I think we'll have to drop down. So,
I will probably, what I'll probably do, I will have to likely modify Logan's job description in accordance with that, so that we have it up to date. And so I will go ahead and do that. I don't think mine will need to be, you guys are the evaluators of whether I'm meeting my job duties, so, but I will make sure to do that with Logan. And I also want to make kind of a comment that it's not that we haven't prioritized complaints or reviewing of complaints.
yeah, I didn't mean to imply otherwise.
I think I'm just trying to make that clear for maybe those
But I
listening,
think-
just that it's
I
been
was not
a,
trying to imply otherwise, but I was publicizing the fact that you spent the part of your time spent on outreach and education, which is also critically important, took away from that other effort. And based on circumstances, and since we're not supported otherwise, that, okay, well, we'll simply won't do that part as much anymore. We're going to focus on those things that are the day-to-day things that we seem to get now.
okay,
Okay. What I have here is written in is add discussion about subpoenas.
I just wanted to bring this up because, it's my understanding that the commission doesn't have subpoena or perceives it doesn't have subpoena. But in the statute, it says the commission may require the testimony of a witness or the production of a book, record, document, data, or other object at any of the commission's investigative reviews or proceedings and so on. And what triggered that, so that's in the statute. And that came in 2021, I believe. But what triggered that discussion, or my thinking was that in House Bill 1360, there was testimony from the governor's office that said, of course you have subpoena authority. So the governor thinks that the commission has subpoena authority, but the commission may not think it has subpoena authority. And the Attorney General says that the commission believes the commission doesn't have a subpoena authority, right?
I'm not sure about that last
I'm not.
statement.
So I went back to the 2021 legislation to review that. And there were some of the language that was taken out during the committee process consistently referred to this text that I quoted as commission may require. They referred to it as subpoenas. And so some of the commission's investigation is being held up because the commission's not using subpoenas. So what would happen if the commission used a subpoena? Why not?
So so I think that the position that the commission has taken and that we've articulated is not that we don't have subpoena power, that we don't have a process to enforce the subpoena, that is not clearly outlined in a rule or in a process somewhere.
Not even to enforce it, how to issue it.
How to
enforce
issue it.
What that process looks like, not that the power itself isn't inherent. There's just no procedure. It always comes back to procedure. There's no procedure out.
So, but what is a subpoena if you can't enforce it? It's,
It's a piece of paper.
it's nothing. So in my mind, this language obviously means something that the commission may require. And so why shouldn't we, as a commission, why shouldn't we adopt the policy or rule to issue subpoenas and the process for compelling if they refuse to respond? That's just my thinking.
Are you
And
thinking as a rule?
whatever it takes to get a subpoena issued and enforced. That's my thinking.
Would there be any merit in asking for an attorney general's opinion? Do we have subpoena power? Since
I think
they're talking out of both sides. So that, I mean, sometimes they say we do and other times they act like we don't.
Didn't we have one?
Mm-mm.
We never had an attorney general's opinion.
Not on subpoena power, no.
I'm suggesting, this is a suggestion. I'm suggesting that the commission adopt a process, whether by policy or rule, whatever the general counsel tells us. And then when the appropriate situation arises, issue a subpoena to compel testimony or evidence.
Signed by the chair based on the information in the
Signed
statute.
by the chair based on a decision of the commission.
Yeah. Based on the Constitution.
Yes.
Yeah.
That's no, it's a suggestion. But I could make a motion if somebody wanted me to, but I
I'll
want
second
to.
it.
But I want to talk about it because I want to go to the right place with the right process.
For all these years, we have talked about not having the power, even though that language is in there,
Not having the process.
not having the process.
Yes.
Did Paul and you ever talk about this?
About the process. So Paul and I had discussions, Logan was there as well, that it is inherent. So there's two spots that in section 3 of the Constitution, it says that the commission may investigate alleged violations of such rules, this article, and related state laws. So that there's potentially inherent authority within that, that if we're directed to investigate, that should include subpoena power.
Which is
And then And then it's been supplemented by the legislature. What?
I did say something.
Yes.
So this whole discussion, I took Dave's request for a memo to include this issue within that discussion, based on everything that we've gone through as a commission with 1360, with this issue, with certain complaints that we have, that this issue needs to be analyzed in that context and in the changing context of the complaint process now. So I had already contemplated including that. If there's something specific that you'd like me to address regarding that, please let me know and I'll be sure to include it in the memo. But I don't know if that's helpful for the discussion you're having, but just so you're aware.
So in your memo, would that highlight our lack of process for that? Not highlight, what's the right word? Would recognize the fact that we don't have a process and that needs to be fixed? Or, I guess, I'm asking too soon because you can write the memo, or is it something that you simply address that, well, we probably do have authority, we just gotta have a process.
So let me cut to the chase here.
Okay.
I move that staff develop a process, whether by rule or policy, to for the issuance of subpoenas when necessary, and the enforcement of subpoenas if necessary. And bring that proposed process back to the commission for review and possible action.
Second.
Any additional discussion? Any discussion from Logan and Rebecca that something we missed or we're mucking up a little bit by?
Nope,
Okay,
nothing from me.
Alicia, call the roll.
Dave
Vote.
Anderson,
Aye.
Cynthia Lindquist,
Aye.
Ward Kozer,
Aye.
Ron Goodman,
Aye.
Murray Stacy.
Aye.
Motion carried. Okay, so
Okay,
go ahead,
That second
please.
issue. So there may be situations where when the commission is aware of a possible ethical violation, either it comes to the attention of the staff when doing an investigation, or a commissioner may be aware of an ethical violation. So that it comes in two separate directions. And so a commission, and the statute says any person may file a complaint. Well, a commissioner is a person, individual, but that creates kind of a conflict of interest situation because you're filing a complaint, and then maybe you're either acting on it or recusing yourself from it, and you're associated with everybody else. That's one issue. But the other issue is, let's say that during this investigation, complicated investigation, staff suddenly becomes aware of, my goodness, there may be a criminal activity going on here, and nobody's made a complaint. And because the investigation is confidential, nobody probably is ever going to make a complaint. So my question is, should we adopt a process for handling that should the situation arise? Because it's complicated. It creates a complicated situation. And to in effect bring the complaint, investigate the complaint, and then vote on the complaint all internally. If you don't do that, however, a possible ethical violation may never get addressed or resolved. So I just wanted to put that out on the table. What do we do in that situation?
So that,
I
that,
know you've likely thought about this for hours and hours. Right?
Logan probably has dreamt about it. Yes. So to start off, part of the reason that we brought House Bill 1360 was to address this problem. When the commission learns about something, but somebody isn't willing to come forward, or there is nobody to come forward, we learn it through a separate investigation, or if I had the number of times that people approach me and say, were you aware of X, Y, or Z? And then I say, oh, no, I'm not aware of that. But they are not willing to bring a complaint because of,
Now you're aware of it.
but now I'm aware. So it puts me in a very unique position, and I think it would be similarly applicable to all of the commissioners, that now we are aware of an ongoing issue. And the question is now, what do we do with that? if somebody isn't willing to have a complaint under the statutory complaint process processed or filed.
And is it still a complaint even though they're unwilling to file it since they told it to you? That's also a concern.
That's also a concern.
Well, if it's not a formal complaint, it still is an issue. So can there be a separate non-complaint process, perhaps by rule, that deals with that situation? And then you would be addressing it, perhaps like the draft rules that you've already drafted to implement 1360.
So that was one of the reasons, right, for 1360 was this exact situation. And there are rules that correspond with 1360 that function differently than the statutory framework. So I guess the question would be, does the commission want us to look at adopting a rule that would function similar to the way 1360 would, where the complainant wouldn't be part of it, and it would be maybe more of an informal process, or maybe more of a formal process, depending on, but a different process altogether.
I believe it was a discussion when we were forming 1360. Well, what's the contingency if this doesn't work? We're still left with a process that is unworkable to some extent. What should the commission do if the legislature doesn't buy into that? I mean, it's kind of that landscape with some caveats because there are some reforms to the complaint process with the budget bill, but also, I guess that has been an ongoing question. What should the commission do in that circumstance?
Because there may be some pushback from individuals that say the commission shouldn't be initiating its own process, and I understand that. On the other hand, the commission shouldn't ignore potential ethical violations, even if there isn't a complaint. So you got these competing
There's competing interests.
interests. I'm more persuaded by the competing interest of the commission investigating something even if it's not a complaint, if the commission believes there's an potentially ethical violation.
Any other discussion? Something we should take on?
Do you want me to push the envelope here?
Okay.
I move that the staff respond to the commission with a process for investigating potential ethical violations, even if a formal complaint hasn't been filed with the commission.
I'll second that.
Any other discussion? Okay, Alicia, call the roll.
Steve Anderson,
Aye.
Cynthia Lindquist,
I,
Ward Kozer,
Aye.
Ron Goodman,
Aye.
Marie Sigsby.
All right,
Motion carried.
I'm done.
Hey.
Can I ask a clarifying question? If we do that process in the form of, maybe it may not take the formal version of a rule, but draft it like a rule.
I just said process.
You said process, and I wrote down process, and
It's
I'm,
whatever.
Okay.
Whatever.
Whatever's easiest.
Yeah, whatever works.
conversation before too.
language always mattered. Hence why I was seeking
Well,
clarification.
especially throughout our conversation today, because we've used formal guidance and formal advice. The other one, standards versus guidelines. processes versus rule.
I
But-
use the word process because it could be a formal rule, or it could be a policy and a rule, or it could be different things.
It gives us the flexibility to adapt.
To whatever we find.
Yeah.
Or learn.
But you understand where I'm coming from, right?
100%.
Well, and my point for bringing it up is that, because we've had these conversations about words and language definitions and that, but just so we're all cognizant as a body. that Our staff will clarify for us when it comes forward.
Lead us in the right direction.
Yeah.
So we hope.
Okay.
Next item is mock complaint overview and hearing.
So this is what you guys requested a few months ago, is to do a mock complaint, kind of more for the public too, to walk through. I can't remember when this was requested, maybe January or February, or was
It
it
was-
even November?
It was originally a discussion when we were talking about 1360 and a new process. What would that look like?
Yeah.
Well, now we're reverting to the complaint process. At the commission's request to do this mock problem. I'll note that we did not have time to adapt the new changes in Senate Bill 2004. So I'll just note them as we go through it. But that's where we are.
So basically then it's still an ongoing project.
It's
It's
ready
ready.
to do.
Oh,
It's ready to do. We just didn't modify it since
so it's just.
Friday afternoon.
Not modified yet, okay.
we don't plan on modifying it either, Dave.
Okay, fine.
Have Alicia bring it up.
So how do we, how should we proceed from here for the mock complaint overview and hearing?
So my suggestion would be to walk through the problem itself, just to give an overview of the problem. And we could do not a full-blown mock hearing, but just a general outline of what a hearing.
Kind of a
would look
tabletop
like.
discussion?
Yeah, and how
Okay.
the procedure and how we walk through it.
I like those.
What do you call this in the military where you
Tabletop.
is that what it is?
Yeah.
Okay. I thought there was a cooler definition for it. You guys have lots of cool definitions for stuff. I was expecting a good one.
We just called it mock complaint because they
Yeah.
call it mock trial in law school.
We aren't very creative.
Okay,
So you have the problem there, a problem overview. We tried to make it sound fake because it is fake. So we created a fictional department and public official in state government. So it is now the North Dakota Department of Forest Creation. The idea here is that it will show you as commissioners, but more importantly, the public, since complaints are confidential, an overview of the whole process from receipt to complaint resolution. So we did that. This document, the first document you have, is kind of like a mini report and recommendation, so the public is aware what those look like when a complaint investigation is over. But we've also created sample documents throughout for how what we receive as commission staff, what the commission receives at certain stages in the process, just so we can demonstrate those as well for the public's benefit. So again, we created a fictional public official in office. It's all tree related. We thought it was kind of fun, so.
Do you want to emphasize where a lot of this
Yeah,
material
so-
came from? Because this was,
Yes, a lot of this was created with ChatGPT because we keep talking about how our time is valuable. So we use ChatGPT to draft some of it substantially and create these fake facts. So again, disclaimer, it is not real, and any resemblance to anything real is coincidental because it was made with ChatGPT. So there were 4 things that we wanted to highlight that come up during the complaint process. One would be a required criminal referral. Now with Senate Bill 2004, we know that's discretionary, so just keep that in mind. If it's signed into law, I always need to caveat that we don't know where it's at right now. 2, informal resolution. 3, an uncooperative witness / lack of that clear subpoena process that we just discussed. And then 4, a potential conflict of interest for a commissioner / staff, because that can diminish the commission's resource if there's a recusal or a potential conflict that just comes up in the process itself. So again, following this title page, it's just a abbreviated version of a report and recommendation what the commission receives at the end of an investigation. Real reports and recommendations will reference the investigation file and the underlying documents / evidence that's found during an investigation that the commission also receives and the respondent receives before that final hearing. So again, we made it in summary form and we annotated quite a bit of it to save time, but it explains what's omitted and why and what it would do. Yeah, and then throughout there's some footnotes to the sample documents which are attached to problem as examples. So if we go to the next page, I'm just going to walk through the report here. So
Do you want to start with the complaint that we would have received, or do you want to start with this?
yeah, why don't we go to the attachments, Alicia?
There you go.
So we created a mock complaint so you can see what it looks like when we receive it in the office. So this is what it looks like when somebody fills it out on our website. We receive a PDF of it. They put their contact information there. It does 2 things. One, it tells us who filed it so we can contact them, but also if they meet the requirements to be a complainant, whether they're a North Dakota resident or the other 2 things that are licensed in North Dakota or they're subject to a quasi-judicial proceeding in the state. And then the complaint details come after that, who it's against, their job title, the date of the alleged violations, and then a description. So this is the most important part, obviously, of the complaint, the allegations. But when you have a citizen who, it's usually not an attorney, usually not assisted by an attorney, the allegations in a complaint are very minimal sometimes, or sometimes there's a lot of words, but there's not really much to what's presented in the complaint. So going through it and trying to figure out what actually is there can be challenging when doing that initial review. But here it's a really simple one, 2 paragraphs, not really even 2 paragraphs, but they're saying Director Oak Ridge oversees a legislatively enacted program to plant trees and create new forests in North Dakota. He owns the Giving Tree Company, which made a lot of money on the program, and then they say that's a conflict of interest. And then there's an allegation of bribery, that he bribed this legislator to bring the bill in the legislature in the first place. So this, again, we made this, so it kind of gets to the crux of the issue, but there's bribery and conflicts of interest allegations in the sample complaint. So then if we scroll down, then we get to the confidentiality designation for the public official, or for the complainant, excuse me. And this complainant, John Mistletoe, he chose to keep his name and address confidential.
Did you make up the names or did?
ChatGPT did a lot of it.
Okay.
I made up where he was from. Did you see that? He's from Oaks.
Oh,
That one we could find.
That
It was tree related, so.
yeah, great.
So Mr. Mistletoe just chose to remain confidential, so that'll come back later in the process. So we received that complaint. Again, the commission's well aware, step 1 is the initial review. So we as staff do the initial review completion report. Once that is done, should get there. So here is our form that we use in the office. Again, it's a checkbox form. It's made to be straightforward so that the commission can review these easily when it comes time for a meeting, but it's split up into 2 things, really. personal jurisdiction. Does the commission have jurisdiction over this person? Yes, check a box and explain this one. He's a public official. He's an appointed official in the Department of Forest Maintenance or Creation. It got changed a couple times, so if things aren't consistent, please excuse them. Then we have the subject matter jurisdiction box. Again, this was a conflict of interest, so that's within the commission's rules, but also it references a bribery allegation. And then, as you can see there, there's 2 statutes cited for potential violations. So that means that during the initial review, commission staff actually found a different statute that may also apply and then corroborated them by publicly available information. So then there's an explanation box if we scroll down, or there's more information. So this is what we'll do usually in a initial review, provide the commission with more information on why the recommendation that's above is being made. So again, here we have the current statute that requires the commission to criminally refer matters when the commission believes the complaint contains allegations of criminal conduct. In this fact pattern, we were able to corroborate that the contract shows it was signed by the state with the Giving Tree Company, which is Mr. Oak Ridge's company, as shown on his statement of interest that he filed with the Secretary of State. And then based on that, commission staff also requested that legislator's statement of interest for the fact pattern, which also showed he had an interest in that same company. So there was some corroborating effort done before it is recommended that the commission refer it to law enforcement. So then that's, the boxes are a little out of order, but number 3 is next steps. And you can see that the further review will pause until the commission has the opportunity to discuss a potential criminal referral. So that then goes to the commission at the next meeting for the commission to discuss in executive session.
So we're well aware that you guys have seen these forms many, many, many times, but the public has never seen a form like this. Hence why we included these so that they could see what we are doing internally when we review these complaints during that initial review stage.
So again, just following the fact pattern here that we created, let's assume that the commission did refer it to law enforcement. Again, this would be the state's attorney with jurisdiction. That's in the sample report and recommendation that that's what happened. And there was a prosecution that resulted in a plea agreement. If you want to read the fake details, they are in the fake report. But then after that, the commission receives it back. After the prosecution happens, the commission receives it back. So we need to reevaluate, okay, what stage were we at in the process? Well, initial review was completed. So under this fact pattern, you move into informal resolution. And that's when both the complainant and the respondent receive our standardized informal resolution request form. So it goes out to them with the complaint number already filled in, and then they need to check a box and provide the commission with some information on whether they want to engage in that process or not, and how best we can accommodate them. But then if you'll scroll to the next page, Alicia, please. After the accommodation questions, number 4 really gets to the crux of the issue. What do they believe a reasonable resolution of the complaint would be? And usually we will get something back like this sample one said. You need to pay back all his money as well as resign from his position. And maybe in this fake instance, this is a reasonable resolution. Who knows? Again, it's fake. I can't emphasize that enough. He needs to resign. It's what they're requesting.
We're not really trying to create a forest creation program.
Any questions at this point? You're all well versed, so.
So this has all been done independent of a hearing?
Yes.
Yeah, we're not at the hearing yet.
This
Yep.
is all the process before we even get to that hearing.
Get to
The
that
hearings
point,
at the
okay.
very end.
Okay.
So in the,
One second. So did you get to the informal? You already did this,
I
right?
just walked through it.
Okay, yep. So this is again a form, you guys don't see this usually, the informal resolution, but this is what we electronically have them do. So that's another good one for the public to see as well as the commission.
Yes, and that really only goes to us as staff who's trying to mediate the complaint. We do not exchange them with, like, the complainant does not see the respondent's informal resolution form, because then they know the background and the details of what is going on. And usually you'll see that with a lot of mediations in the court system, that they won't exchange those statements because it's for the benefit of the mediator, which in this instance, it's us as staff trying to mediate the complaint. So I need to check the facts here just. So I think here with this formal resolution, the facts we came up with, which is a common occurrence, is that both the complainant and the respondent agreed to engage in informal resolution, and they negotiate in good faith, because most of the time they do. They're just very far apart, and sometimes their expectations are not realistic. And you have the added caveat of the complainant in this case is confidential, so we can't bring them into a room to have a conference. We have to go back and forth with somebody. Usually if they're a confidential complainant, it's phone calls to that person to get their position, and then communicating those to the respondent, getting maybe a counter offer and taking that back and forth. So again, in most instances that can go on for some time. Here we said it went back and forth for about a month, because that realistically occurs quite often. But then it becomes very clear at some point that they're never going to come together and reach a resolution. So one of them has to say, well, I'm done. I'd rather proceed to an investigation. Then at that time, the commission can move the complaint into an investigation. Now with the amendments to 2004, we move it to a different process where the commission can negotiate to settle the complaint instead of moving it into an investigation right away. But here we're operating on the current law, so we'll continue to the investigation. And at that stage, the respondent will receive a form letter like this from myself that says, we are notifying you that the investigation has begun pursuant to the laws that authorize said investigation. Again, we explain that it happens when they're not informally resolved. This will obviously change with the new amendments to the law, but then it gives an outline of how the investigation proceeds. It's by the executive director and commission staff. The commission ultimately makes the determination. Again, then the confidentiality piece, but they are notified at each step in the process of where things are at. We just didn't include the other earlier letters, just for the record, because this gets quite lengthy. So let's say we go through the investigation. The executive director then, with the assistance of staff, prepares the report and recommendation for the respondent. Once that is done, we will meet with the respondent and go over the pre-hearing acknowledgement and stipulation, which lays out how they will receive the report, how they will receive the investigation file, which becomes the record, informs them how to submit their response to said report in person and in writing. The statute says they have a or. The stipulation allows them to do both. I think the commission prefers that they do both, so they have as much information as possible to make that decision. And then it outlines the commission meeting and the hearing on complaints. So again, this is from Century Code and from the commission's rules on how this operates, but that they'll meet in executive session because complaints are confidential. The meeting is audio recorded, or it can be video recorded, depending on how the commission sets it up. If they need accommodations, please contact the commission. And then the commission will conduct a hearing at that meeting and outlines the procedure for how that happens. with the chair, the chair's designee determining the order of presentations and the time allotted. So when we were developing this form for pre-hearing acknowledgement and stipulation, it was kind of not clear. The statute doesn't provide a process. The rules don't necessarily provide a process on how much time is the default or what does that look like. So it's, again, modeled after a bit of court procedure. This one specifically really the Supreme Court, but again, the initial person, the executive director and staff get 30 minutes, then the respondent responds in the 45 minutes, and then there's 15 minutes for rebuttal, essentially. In practice, will this time be needed? Probably not. That amount of time won't probably be used by us as staff or the respondent, but it's allotted just in case, so they can, each side can essentially make its case regarding the complaint. And then once that hearing is done, the 5 commissioners meet in executive session outside the presence of anybody on staff who assisted with the investigation, outside the presence of the respondent, any witnesses, their attorney, et cetera. It's just the 5 of you who deliberate and consider the record, the report and recommendation, the hearing, any response provided by the respondent. And then the commission makes its decision during those deliberations and informs the staff and the respondent of its decision.
So the commission will have to, in effect, designate a secretary in case they're going to amend the proposed order because the staff will not be available. Technically.
Correct.
That is correct.
You want to type this?
Yes, take a break.
Okay,
Starting with you, Ron.
What's that?
So let's all return to court 2. 10-minute break. That's a very complete